This is No Cards from Tort Law, Part 2, picking up with the maximum recovery rule, discussing a remitter versus an additor. In a remitter, the judge may adjust the jury, adjust the verdict if the jury was unfair, and in a way that it would be lowered, the damages would be lowered, would be a remitter, and an additor would be if they weren't sufficient. Now, there's 5 cardinal elements of damages, types of damages, I would say. There's economic and non-economic. So, economic would probably be giving the defendant let's read non-economic right now is past physical and mental, future physical and mental expenses, loss of earnings capacity, and permanent disability. Under the common law, wrongful death and survival is means that the cause of action for personal injury was extinguished under the common law by the death of either the plaintiff or the defendant, and there was no separate cause of action that arose to compensate the family of the person who was injured. And the common law was replaced by statute. Most jurisdictions now allow either or both actions to be brought, and they're referring to wrongful death or survival. Some require an election between the two. A few have merged the causes of action into one new cause of action, and most jurisdictions have a provision that prevents double recovery, for example, by the estate and also by the widow. In the survival statute reverses the common law rule, providing that a cause of action for personal injury survives the death of the plaintiff and or the defendant. No new cause of action, there is always a cause of action. The cause of action the decedent would have had survives the death of either party. If it is the defendant who had died, the claim must be brought against the defendant's estate. If it is the plaintiff who has died, usually the claim can be brought by the executor or administrator of the estate on behalf of the heirs. Proceeds go to the estate. Creditors of the estate are paid first, then the heirs under the will or the intestate statute of the jurisdiction. Damages are those the decedent would have been able to recover. Defenses are those the defendant would have been able to argue. The statute of limitation runs from the date of injury. Intra-family immunity may no longer apply because the relationship was terminated at death. So if you couldn't sue your spouse because of intra-family immunity, if your spouse negligently pushes you down the stairs, negligently causes you to fall down the stairs, that relationship was severed when you died. You still have a cause of action against your ex-spouse. In the wrongful death statute, there is a new cause of action created by the death of an individual due to the tortious conduct of another. This is a new independent cause of action created on behalf of certain beneficiaries defined in statute, to be brought by one of the beneficiaries on behalf of all of the beneficiaries or by the personal representative of the defendant. The jury usually allocates the damages among the statutory beneficiaries within the same class. And proceeds are protected from the decedent's creditors because the cause of action belongs to the beneficiaries, not the estate of the decedent. So that's like completely new information compared to what I read in the book. Thanks for sharing. Actually not ready to proceed yet. So, no, we are. We have negligent entrustment tort. I don't even know what that is, but it's in my hand. Oh, I still don't know what it is. Duty of care under negligence is defined as the proposition that whenever one is by circumstances placed in such a position with regards to another that everyone of ordinary sense would at once recognize that if he did not use ordinary care and skill in his own conduct with regards to those circumstances, he would cause danger of injury to the person or property of the other. A duty then arises, thus ordinary care and to use ordinary care and skill to avoid danger. So that's what we mean by a duty of care. Unreasonableness from the statute is an act is one which a reasonable man would recognize as involving a risk of harm to another. The risk is unreasonable and the act is negligent. If the risk is of such a magnitude as to outweigh what the law regards as the utility of the act or of the particular manner in which it is done. In deciding negligence, consider 3 factors. 1, the social value of interest to be protected from act. 2, extent of chance interest will be advanced or protected. And 3rd, extent of chance interest by alternative conduct. Another definition of negligence is a person acts negligently if the person does not, I already read this, does not exercise reasonable care under all circumstances. Primary factors to consider in ascertaining whether the person's conduct lacks reasonable care is the foreseeable likelihood that a person's conduct will result in harm and the severity and the burden of precautions to eliminate or reduce the harm. Magnitude of risk. In determining the magnitude of risk for the purposes of determining whether the actor is negligent, the following factors are important. The social value which the law attaches to the interests which are imperiled. 2, the extent of the chance that the actor's conduct will cause an invasion of any interest of the other or one of a class of which the other is a member. And C, extent of harm likely to be caused to interests imperiled. And D, the number of persons whose interests are likely invaded if the risk results in harm. And the precaution, which should be analyzed in the cost and benefit analysis, includes 5 factors. 1, the character and location of the premises, the purposes of the premises. 3, the probability of injury. Excuse me. And for the cost of the precaution and necessary to prevent injury and fifth, the benefit of taking that precaution, which might be like building a fence around a lake, because most of the time lakes are, there's a word for them, that I can't remember, but if the but in determining whether you need to put up a fence that's like 5 feet or like 6 feet with barbed wire, your decision would consider the character and location of the premises. Is it in the middle of like a huge populous area that with lots of passerbys, or is it in the middle of nowhere? And 2, the purpose of the premises. Is the lake in a park, or is the lake private for generating energy? 3rd, the probability of the injury, meaning, do children swim in this lake or nearby lakes ever? And the cost of the precaution necessary to prevent the injury is a 6-foot fence with barbed wire is more expensive than a 5-foot fence. But the benefit of the precaution, is this lake like also a quarry that people jump out of all the time, or would like to jump off and could lose their lives? In which case, putting up a fence could be worth the expense. Proximate cause and cause and fact are the last 2 pieces that I'm going to discuss. For cause and fact, this is tested by a but-for test. An act or omission to act is the cause and fact of an injury when the injury would not have occurred but for the act. Greater than one factor doesn't negate causation fact, but there's a substantial factor test. Several causes commingle to bring about injury if it is sufficient, if the defendant's conduct was a substantial factor. So it is sufficient to sustain a cause of action if the defendant's conduct was a substantial factor. And alternative causes approach is another way to test for cause and fact when there is more than one factor that causes damages. I don't have the definition written there of what the alternative causes approach is. I don't think I'm going to find it before the test. Causation, which is proximate. Defendant is liable for all harmful results that are the normal incidence of and within the increased risk caused by his acts. And proximate cause limits liability for unforeseeable or unusual consequences of one's acts. So causation. The defendant is liable for all harmful results that are the normal incidence of and within the increased risk caused by his acts. Proximate cause limits liability for unforeseeable or unusual consequences of one's acts. Proximate cause is not the but-for test. That would be cause and fact. This is more like a chain of events and breaking the chain. Another example or another definition of proximate cause is consequences which follow an unbroken sequence without an intervening efficient cause from the original negligent act are natural and proximate. Proximate cause is decided by the court to deny liability for otherwise actionable conduct based on considerations of logic and common sense, policy, precedent, and judicial intent. Meaning that if it's unreasonable for the defendant to pay for like the entire city being burnt down because it was his fault, that his shed nearby his train caught fire. I mean, he's responsible for the spread from the shed to like another house, but and maybe a couple houses, something within reason. But he's not going to be responsible for the fact that all of the houses are right on top of each other in a huge city and there was no way to control the fire. That's the end of part 2 for right now.